The Justice Department keeps getting its ass kicked in court, especially in Washington, D.C., which is weird because President Trump assured us that he fixed crime in the nation's capital by flooding the streets with masked men in tactical gear.
Washington, D.C., you'll be happy to know, is a free and safe zone. It's so safe.
And Attorney General Pam Bondi says they've arrested upwards of 1,000 people and confiscated more than 100 legal guns. But is crime really fixed if your prosecutors can't manage to indict anyone for breaking the law? The U.S. attorney couldn't even get a grand jury to indict that guy who threw a sandwich, and he told the cop who chased him down, "I did it, I threw a sandwich." Meanwhile, judges are saying stuff like, "This is without a doubt the most illegal search I've ever seen in my life," and "We don't just charge people criminally and say, 'oops, my bad,' and accusing the government of false imprisonment." So who is to blame for this debacle? Is it U.S. Attorney Jeanine Pirro?
Close. It fell off the aircraft carrier into the ocean.
What? Again? Or are D.C. residents just nasty and ungrateful for everything the administration has done to clean up their city? And what's so grand about a grand jury anyway? We gotcha. Under the Fifth Amendment, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. So that's a lot. Let's define our terms. A capital crime is something you can get the death penalty for, and an infamous crime is anything that's punishable by 6 months imprisonment and or a fine of $1,000. A presentment is a charging document issued by the jurors themselves. It's not really used in the federal system anymore, but an indictment is a charging document accusing someone of committing specific crimes. And a prosecutor can't just indict someone for a serious crime because she thinks they broke the law. She has to convince a grand jury to authorize it. Now, that's not the same as a regular trial jury where you get called for jury duty at the local courthouse. That's technically a petit jury. Here, I'll let the federal judiciary explain that one.
There are two types of juries, grand and petit. A grand jury determines if there's probable cause or enough evidence to charge a person with a crime. It consists of 16 to 23 people, and proceedings are not open to the public. A petit jury, which you're probably more familiar with, is also called a trial jury. It consists of 6 to 12 jurors who examine the facts and render a guilty or not guilty verdict in a criminal trial.
That there is an excellent use of taxpayer dollars. Okay, so a panel of grand jurors is made up of 23 citizens of the district who meet regularly to consider criminal cases presented by the U.S. attorney in the district. And serving on a grand jury is a serious time commitment, much bigger than your regular petit trial jury. Grand jurors are summoned for some period of time. Sometimes it's 6 months, sometimes it's longer, depends on the district. And they don't meet every day. Maybe they meet every Friday or every other Wednesday. And while petit jurors usually hear one case, grand jurors are impaneled to hear a bunch of cases that prosecutors in that district want to charge. So they sit in a room, they listen to evidence, and they vote on whether to sign the proposed indictments. You've probably heard the expression, a grand jury will indict a ham sandwich, and that's a joke about how much the grand jury process is tilted in favor of the prosecution. To start with, the person charged isn't present and can't rebut anything the prosecutors say. And while the rules of evidence at a trial are pretty stringent, prosecutors can introduce hearsay or even just an affidavit from a police officer summarizing the case to a grand jury. They don't have to convince the grand jurors beyond a reasonable doubt that the target committed the crime. They just have to show probable cause, which is a much lower standard than in a regular trial. And the grand jury doesn't even have to be unanimous. The panel is 23, and only 16 have to show up to constitute a quorum. It only takes 12 jurors to indict, no matter whether there are 16 or 23 jurors in the room. So yeah, the prosecutors have pretty good odds. A grand jury indictment is called a true bill, and if the jurors refuse to indict, that's called no true bill. But that is very rare. It happens in less than 1% of cases presented to federal grand juries, and many federal prosecutors will go their entire careers without seeing one. And yet, the U.S. Attorney's Office in D.C. is seeing them all the time. In fact, they got no-billed 3 times in one case alone. I don't have the words to explain to you how unbelievably weird that is, although I have some guesses as to why. And it is not because Jeanine Pirro, the former Fox News host and current U.S. Attorney for the District of Columbia, is spectacularly good at her job.
If you spit, we hit.
But first, let's talk about D.C. and why it is so weird. In a normal state, the U.S. Attorney's Office prosecutes federal crimes and state prosecutors prosecute state crimes. But D.C. is not a normal state. It's not even an abnormal state. It's our nation's capital, and the framers, in their wisdom, wanted it to be outside of any state, which made some sense when it was a backwater with just 5,000 residents that hosted a part-time legislature. Now, the city is home to 700,000 people with no representation in the Senate or the House of Representatives. But because D.C. is not a state, the U.S. Attorney in D.C. prosecutes almost all adult crimes, which is the reason Jeanine Pirro is mucking around with low-level assaults, because that's her actual job. I mean, okay, it's not the only reason. She's mucking around with assaults because President Trump ordered her to fix crime in D.C. by cracking down on every minor infraction from loitering to public urination. It started on Trump's second day in office when Deputy Attorney General Emile Beauvais instructed every U.S. attorney that in the absence of unusual facts, prosecutorial discretion at the Department of Justice and the U.S. Attorney's Office is bound by the core principle that prosecutors should charge and pursue the most serious, readily provable offenses. That effectively removed prosecutorial discretion to consider the totality of circumstances and prioritize serious crimes over nuisances. And then Trump specifically ordered the DOJ to bring the hammer down on D.C. when he declared a criminal emergency, despite the fact that there's actually been a major decrease in crime in the capital. Trump surged troops into D.C., where they've been harassing students at the train station, tackling guys delivering food on bikes, and then, when they get bored of that, picking up trash in federal parks wearing camo and high-res vests. Because I guess they're in deep cover? Trump even tried to take over the city's police force. Pirro ordered her staff at the U.S. Attorney's Office to maximize criminal charges against anyone arrested in the administration's crackdown on street crime and charge them with stiffer federal crimes whenever possible, which quickly overwhelmed judges in both federal and municipal courts. The Washington Post has an account of a recent Monday in D.C. Superior Court where 122 people who'd been arrested over the weekend and held in jail made their initial appearances and entered a plea on whatever misdemeanor they were being charged with. In the past, if cops picked up someone for fare jumping or smoking a joint in the park, prosecutors probably wouldn't bother to charge him because no one has time for that stuff. Now, after Pirro's order, they're charging everyone for everything. And the court system is not set up for this. Judges, court staff, and attorneys are stuck there until 9 p.m. or even later, wading through nuisance charges that are likely never going to stick. Which is something to keep in mind when Attorney General Pam Bondi brags about 1,000 arrests as federal agents surge through the city, and in federal court, it's even worse. So if you ever done anything that risks getting slapped with a nuisance charge, you're probably going to want to take back control of your online privacy. That's because data brokers vacuum up your personal data from all corners of the internet and sell it to anyone who wants to buy it. But you can fight back and take control of your personal data by signing up for today's sponsor, Incogni. Incogni removes your personal data from online data brokers by searching the internet, reaching out directly on your behalf, and forcing them to take down your personal info. If those data brokers resist, Incogni will take care of that too, because Incogni fights back. Those data brokers are the reason why in the US you can search your name and find a bunch of websites that will give anyone your home address, phone number, and extensive history. It is shocking how easy it is to find all that information. It also might be why you're getting so many spam calls lately or even had your identity stolen. I've been using Incogni for years, and in that time, I've been on hundreds of lists, some of which had a high sensitivity score, meaning the broker had tons of data on me. Luckily, Incogni has completed hundreds of takedowns for me over the years. I could never do that myself, so thank you to Incogni for weeks of work and adding me to over 40 suppression lists. And Incogni will continue to conduct ongoing removals because even if the broker removes your data once, they can collect it and publish it again. So if online privacy is important to you, give Incogni a try. If you click on the link on screen or down below, you can try Incogni risk-free for 30 days with a 60% off discount and get a full refund if you're not into it. And if you keep it, you'll still get the exclusive 60% discount so long as you use our link or the code LegalEagle, all one word. So sign up for Incogni or we will see you in court. Now, one of the crimes the Trump administration really wants to crack down on is resistance to immigration raids. Enter the submarine samurai, the hero hurler, the sandwich bandit, known to his friends and the DMV as Sean Dunn. We've all seen that video of the former Justice Department paralegal throwing a sandwich at Customs and Border Patrol agents. And we've seen the video of the 20-man tactical team they sent to arrest this dangerous criminal. And here's Pirro bragging about charging Dunn with a felony.
So there, stick your Subway sandwich somewhere else.
Wait for it. On August 13th, the DOJ filed a criminal complaint against Dunn for assaulting a federal officer. The statement of fact contained 5 paragraphs from a DC Metro Transit cop attesting that Dunn shouted in the CBP agent's face, "Fuck you, you fucking fascist. Why are you here? I don't want you in my city," before winding his arm back and forcefully throwing a sub-style sandwich at him. Now, a criminal complaint is not an indictment. Most of the time, a complaint is used to secure an arrest warrant immediately for someone so dangerous that law enforcement has to take him off the streets before they have time to go get a grand jury indictment. Obviously, Dunn is not that. I think it's safe to assume here that the urgency was the DOJ's need to make that goofy video of the guys in flak jackets busting down Dunn's door. So they filed this criminal complaint to secure a warrant for Dunn's arrest, after which he was released because, what are they going to hold this guy for? He threw a sandwich. He's not the Unabomber. But the complaint started the clock ticking because the government has 30 days from the filing of a complaint to procure an actual indictment, and they couldn't do it. They presented this case to a grand jury in D.C., and the jurors refused to indict. With every advantage prosecutors have, Pirro still couldn't get 12 votes. Now, we can speculate as to why that happened. People in D.C., including one Devin J. Stone, are pissed about federal troops flooding their city and pretending it's some kind of hellhole. And indeed, Dunn has become something of a folk hero. But getting no-billed left the DOJ with egg on its face, so Pirro's office filed a criminal information charging Dunn with a misdemeanor instead of a felony, because a misdemeanor isn't an infamous crime for the purpose of the Fifth Amendment and doesn't require a grand jury to indict. Weirdly, Pirro didn't tweet out a video about downgrading it to a misdemeanor, but believe it or not, that was not the most embarrassing thing that happened to the U.S. Attorney's Office in August. What's more embarrassing than a grand jury refusing to indict a guy who got caught on camera throwing a sandwich at a CBP agent? Try 3 separate grand juries failing to indict the same woman. According to a criminal complaint filed on July 23rd, Sydney Reed tried to physically impose herself between ICE agents and the undocumented immigrants they were trying to arrest. As she was being roughed up by 2 FBI agents on the scene, one of them bruised her knuckles. And so they charged Reed with felony assault on a federal official, except they didn't charge her. Once again, they used this criminal complaint and then congratulated themselves on social media before bothering to secure an indictment. And so, with the 30 days to indict expired, the DOJ had to walk of shame itself back into court and admit that it had tried 3 times to get a grand jury to charge Reed, and 3 times came up empty. Pirro's office had to downgrade that one to a misdemeanor too, just like in the case of the sandwich guy. In fact, the U.S. Attorney has had a ton of no bills since flooding the city with troops. As of this recording, the running tally is 7 publicly reported no bills, although by the time you're watching this, who knows? There's Alvin Summers, a guy who made a wrong turn into a restricted ramp at the National Mall and immediately put his white Ford Bronco in reverse and parked in a legal spot. Upon exiting his vehicle, he was accosted by a cop who demanded his ID and said she would chase him if he ran, and then she attempted to put him in handcuffs when he walked away and refused to interact with her. The officer claims to have been assaulted in the scuffle and, quote, during a subsequent search of Summers' flight path, law enforcement recovered a full vial. Based on the color and smell of the substance inside the vial, law enforcement suspects it to be PCP. Wow, a white Ford Bronco and PCP, they're really leaning into the 90s hits. On August 20th, the grand jury no-billed the case against Summers, and on August 28th, the DOJ moved to dismiss, but they wanted a dismissal without prejudice. That is, the government wanted to reserve the right to recharge Summers in the future, leaving a potential criminal case hanging over him for 5 years until the statute of limitations runs out. And Summers objected to this, pointing out that the arresting officer was wearing a body camera and her testimony was rejected by the grand jury, presumably after reviewing the body-worn camera video. His lawyers demanded that the case be dismissed with prejudice, and finally the DOJ agreed not to charge him with any assault, although they seem to be reserving the right to charge him in connection with the PCP in his flight path. The DOJ also managed to get no-billed in 2 cases where they accused someone with obvious mental health and or substance abuse issues of threatening to kill the president. Natalie Rose Jones posted on Facebook that she was, quote, willing to sacrificially kill this POTUS by disemboweling him and cutting out his trachea with Liz Cheney and all the affirmation present. She also urged the CIA to just find him and drag his ass out and fuck him up infinity. She requested that Secretary of Defense Pete Hegseth order the Army's 3rd Infantry Regiment to arrest Trump and turn him over to the FBI and the Secret Service. The U.S. Attorney's Office in D.C. arrested her and charged her with threatening the president, and they got no-billed by the grand jury, presumably because, come on, this woman is nuts and had no intent or ability to do any of that. And again, the government is trying to dismiss this case without prejudice so it can hold open the possibility of recharging her later, preferably in front of a different judge. In the case of Edward Dana, the cops picked this guy up after he damaged a light fixture outside a restaurant. And in the police cruiser, he claimed that he was a person with intellectual disabilities, descended from Huguenots, intoxicated and, quote, affiliated with the Russian mafia. He also demanded that the police take him back to the restaurant so that he could go back there and destroy more property and beat up the person who called the cops. In the midst of this drunken rant, he claimed that he was not going to tolerate fascism, and that means killing you, officer, killing the president, killing anyone who stands in the way of our Constitution. And that was enough to get a magistrate to swear out a criminal complaint for threatening to kill the president, but it wasn't enough for a grand jury to indict Dana, which is yet another no bill. But then the DOJ did something really weird. On September 4th, 25 minutes before a scheduled hearing in Dana's case, the government emailed Magistrate Judge Zia Faruqi saying that it planned to downgrade the charge to a misdemeanor. And okay, that's what they did with Reed and Dunn, but this time they announced that they'd already charged Dana in D.C. Superior Court with the misdemeanor before dismissing the felony in federal court. And that's more than a breach of protocol. You cannot simultaneously prosecute a guy for the same offense in state and federal court. Not even if you're real mad that the magistrates don't want to detain that weirdo for rambling nonsense in the back of a cop car. So Judge Faruqi hit the roof, demanding that the DOJ explain exactly when and why it decided to re-arrest Dana before dropping the federal charges. He said that the Justice Manual states that the U.S. attorney should only commence prosecution if she believes that the admissible evidence will probably be sufficient to obtain and sustain a conviction, given that there have been an unprecedented number of cases that the U.S. attorney dismissed in the past 10 days, all of whom were detained for some period of time. The court is left to question if this principle still applies. Jeanine Pirro responded by accusing Magistrate Judge Faruqi of being soft on crime and having allegiance to those who violate the law and carry illegal guns, justifying the possession of these guns and constantly pushing for the release of these dangerous criminals back into our communities. For the record, Faruqi spent 12 years as a prosecutor in the U.S. Attorney's Office in D.C. You know, that's the office Pirro has been running for 3 months now. Magistrate judges perform a distinct and important role in the federal judiciary. While U.S. district and circuit judges are nominated by the president and confirmed by the Senate, magistrates are experienced lawyers who are hired by the judges themselves to do some of the administrative work in the courthouse. And a lot of that work involves swearing out warrants and handling criminal complaints, stuff that takes place before an indictment is charged. Once the grand jury returns an indictment, the case gets assigned to a regular Article III judge. But here, the U.S. Attorney's Office in D.C. is rocking up to the courthouse with all these criminal complaints, which is why they're constantly in front of the 4 magistrate judges, not the 24 U.S. District Court judges. So these 4 magistrate judges, who already have a massive caseload, are currently swamped with stuff which in normal times would have been charged as a misdemeanor in D.C. Superior Court if it ever got charged at all. But now the DOJ is bringing criminal complaints so Jeanine Pirro can go on Twitter and brag about sticking it to the sandwich guy, which requires a ton of work from the magistrates, even if the DOJ winds up dropping the cases 3 weeks later after getting no bill. It's just a huge waste of everyone's time. So of course the magistrates are pissed. Take, for example, the case of a man named Torres Riley, who was charged with illegal gun possession after being stopped and searched while leaving Trader Joe's. The officers claimed that they had probable cause for this search because Riley's bag, quote, looked heavy, that's not probable cause. And Judge Faruqi called it, without a doubt, the most illegal search I've ever seen in my life and said a high school student would know this was an illegal search. And he didn't mean that in a good way. Pirro's office put out a statement saying that as soon as she was shown the body-worn camera footage of Riley's arrest, she ordered the dismissal of the charges. But that doesn't explain why her office charged this guy in the first place. Did they not look at the footage before they went to the court and swore out a warrant and put this guy in lockup? And the fact that they did the right thing eventually does not undo the harm. People lose their jobs when they get arrested. They lose custody of their children. It shows up on criminal background checks. They have to disclose it on job applications forever. As Judge Faruqi said, we don't just charge people criminally and then say, oops, my bad. But U.S. Attorney Jeanine Pirro has an answer for that, and it is that grand juries in D.C. don't know what's really going on in their own city where they live. On Fox, she said,
You know, there are a lot of people who sit on juries and they live in, they live in Georgetown or in Northwest or in some of these better areas, and they don't see the reality of crime that is occurring. And my office has been instructed to move for the highest crime possible, consistent with the law, the statute, and the evidence.
Jeanine Pirro, who moved here in May, is going to de-explain the city to its residents. Okay. To be fair to Pirro, she's not the only U.S. attorney getting no-billed. In fact, lawyers working for U.S. Attorney Bill Asaley in Los Angeles have taken to calling their boss No Bill Asaley, because after the protests in L.A., when Trump flooded those streets with Marines and National Guard, Asaley also filed a bunch of complaints which he triumphantly posted on social media, and then he too had to walk them back to misdemeanors after grand juries refused to indict. But in a sense, Pirro's not totally wrong about grand juries in D.C. It's clear that many residents are skeptical of the president's law enforcement surge into the city, if not downright hostile. We all saw the video of the sandwich guy doing his thing, and the grand jury said, nope. The thing is, if Pirro wants to convict these people at trial, she's going to have to convince juries made up of citizens of the district to vote for it. And remember, unlike grand juries, petit juries have to be unanimous. So if she thinks that the grand jurors aren't doing the jobs, I'm not sure what she expects to happen at trial. The technical term for this is jury nullification, that is, jurors refusing to convict despite the evidence because they disagree with the law or they think the prosecution is unjust. And it seems like some of these defendants are doing that same math. Remember the case of Sidney Reed, the knuckle bruiser? Here's a minute order, which is basically a court notation describing Reed's arraignment after the government got no-billed on that felony 3 times and then downgraded her to a misdemeanor. See where it says defense objects to the tolling of the speedy trial clock? The Sixth Amendment guarantees defendants the right to a speedy and public trial, and the Speedy Trial Act of 1974 guarantees defendants the right to go to trial 70 days from their indictment. Now, mostly defendants want as much time as possible to prepare their cases and to argue about the evidence, and so they consent to toll the speedy trial requirement and delay their trial. But Sidney Reed said, bet, because if the government is going to try her, she wants it to be right now. She's going to force them to get in front of a jury on October 14th, a jury of 12 citizens of the District of Columbia, a city that has been under de facto military occupation, who will have to unanimously agree to convict her. Guess we'll find out soon if U.S. Attorney Pirro can bring it on home. Like they say, 4th time's a charm, right?
Now, all this highlights why it's so important to get a great lawyer when you're dealing with your own case. Now, after I started this channel, every week I'd get hundreds of comments and emails from viewers who are dealing with legal problems. And they'd ask, can you help me find a lawyer? Or how do I know if this attorney is any good? And there's a massive gap in our justice system. It's that people don't know how to find the right lawyer for their specific situation. They're scared, they're overwhelmed, and they end up doing nothing or hiring the first attorney who calls them back. And that really bothered me. So I started to wonder, what if there was a different way? What if we could build a law firm that actually lived up to the values that I talk about on this channel: transparency, accessibility, and putting clients first instead of chasing billable hours. A firm where you don't need to pay anything up front and your lawyers only get paid if you do, to maximize your opportunity for justice. So a few years ago, I decided to fix that problem. I decided to start my own personal injury law firm. And honestly, it wasn't an easy choice. But I realized I was in this unique position. I had this platform, this community, and the experience. Not to get rich, trust me, there are easier ways to make money than starting a law practice. But we did it because access to justice shouldn't be a luxury. Because finding the right legal representation shouldn't feel like playing Russian roulette with your future. And when you work with my firm, you're not just getting a lawyer. You're getting a team that understands that behind every case is a real person with real stakes. If we can't represent you, or you're in a state where we don't practice, we'll take the time to try to match you with an attorney in my personal network of lawyers. A national network of some of the best lawyers in the country who actually specialize in what you're going through, located right where you are, not just whoever happens to be available. So if you're dealing with a personal injury, a car crash, a data breach, sexual harassment, a social security or workers' comp issue, give us a call at the number on screen or click on the link below. Now, I can't represent everyone that watches this channel. I wish I could, but what I can do is make sure that when you need legal help, you have somewhere to turn to that you can trust. So whether it's me handling your case or the incredible attorneys we partnered with, you'll get the same principles of honesty and education that we bring to every video. And if you're dealing with a legal issue and you're not sure where to start, check out the link in the description. Let's have a conversation about how we can help you find not just a lawyer, but the right lawyer for your situation. Because at the end of the day, that's what this is all about, making sure that when life gets complicated, you don't have to face it alone. Which is why when you need a lawyer, you don't just need a legal team, you need the Eagle team.